So good morning, everyone. Thank you for coming. I know it's Tuesday morning and it's been a long conference, so I do appreciate that you showed up. Hopefully today's session will be interesting and worth the while. And I'm just going to remind everyone that at the end there are attendee forms to fill out reviewing the session. So I'm expecting gold stars from all of you. Keep you awake. Just a little bit about myself before I start the presentation. My name is Rachel Hirsch. I am an attorney at the Washington, D.C. based law firm of Ifrah, PLLC. We practice in all areas, but specifically in online marketing. I have clients who I represent in regulatory compliance and litigation matters in the online marketing space. Our goal, obviously, is to keep our clients out of trouble, so we will, make sure that their business practices are compliant, and should they, of course, get into some hot water, like we're going to discuss today about some other folks, we are experienced litigators, and we handle FTC investigations, litigation, civil, and commercial disputes. So today's session is called Mo Money, Mo Problems, only scrutinizing FTC settlements. They gave us 7 words to describe our topic, and I thought, you know what, nothing describes my topic better than a rap lyric. So throughout the presentation, you're going to see hip hop or rap lyrics on my slides. And if at the end you can identify who the artist is or who said it, then I will offer a free legal consulting session to whoever is awake enough to get those right. And also it's just fun and, keeps people on their toes. Because it is a very serious topic and I don't want to make light of it, but you have to have some fun talking about what could otherwise be a little bit of a mundane topic. So what we're going to talk about today is the FTC. And the question we're going to ask throughout is, why does the FTC seem to always win? And if you just look at the track record of settlements and cases through the last decade, it just seems like they're always coming out on top. And the reason is because people don't really understand who the FTC is, what the process is, what's the law, and how to navigate through the channels of an FTC case, even before they come knocking at your door and after they come knocking at your door. So we're going to talk about that, hopefully have some helpful tips for you all, because I just settled a big FTC case, and I can tell you from experience, it's not fun, and it takes a long time, and it can be very overwhelming. And the question I get from clients all the time is, why is this taking so long? So we're going to explain why it takes so long. So first slide is the notorious FTC. Hope you get that reference of who I'm referring to there. So in the art of war, what's the first thing you need to know? Know your enemy, right? Who is the FTC? So the FTC is, and I put it in quotes, an independent federal agency. And the reason why I put that in quotes is because it actually receives its funding from Congress. So there are political backings to why the FTC pursues certain verticals or industries more than others. So it's not totally independent, but it thinks of itself as an independent federal agency. It's not like dealing with one lawyer and one plaintiff on the other side. You're dealing with a whole host of people, lots of red tape, lots of bureaucracy. So we have, on the FTC, we have 5 commissioners. Interestingly enough, the current panel of commissioners are 4 women and 1 man. So draw whatever conclusions you want from that as to what kind of enforcement measures there'll be, but somewhat kind of like what this room looks like this morning. The chairwoman is Edith Ramirez, and there's a chair and 4 commissioners. So they are on 7-year staggering terms. So you're never going to have a situation where the entire panel is uprooted and whole new people are set in. That will create lots of inefficiencies. So, certain people leave at certain times and others replace them, but not all at once. So the chairman is actually a chairwoman now, has a fixed term, but really serves at the leisure of the president. So if a Democrat's in office, you're going to likely see someone with more liberal views rather than if you had a conservative or Republican president. And to try to keep the balance and not make it too political, they try to have no more than 3 commissioners from the same political party. But you're always going to have somewhat of a majority, technically, if you have 3 and then 2. So they try to keep it, a little bit balanced. Let's see. So then we have who are we looking at the FTC? So for the FTC, The bureau that we're most concerned with in this online advertising space is the Bureau of Consumer Protection. And they have 7 different divisions. So they have the Division of Advertising Practices, the Division of Consumer and Business Education, the Division of Financial Practices, the Division of Privacy and Identity Protection, the Division of Marketing Practices, Division of Planning and Enforcement, and of course, in red, our very least favorite division, that's the Division of Enforcement. So you're going to ask me, why does any of this really matter? What do I care about how the FTC is set up? Because this is just the Bureau of Consumer Protection here. These are all the people that you need to go through when you have a case. So you actually have, below this like light tan line, you have the staff attorneys who are in each case. They need to report to their regional directors, and then they need to report to their division directors, and then they need to report to the director of their division, and then ultimately they have to get approval from the commissioners and has to go up the chain. So what does this mean? It means your case is going to take a long time. Any aspect of your case, whether it's a stipulation, a consent order, any kind of finality to your case, is going to take a lot of layers of bureaucracy to go through before you get an end result. So for instance, I just settled a case in Texas, which would be the, I think it's the the Southwest region, and the assistant regional director now is Jim Elliott, and he was my staff attorney on my case. During the case, he got promoted. That actually worked to my advantage. He got promoted. He wanted the case off his desk, so it helped move things along. But, while the case started, he needs to go through his bosses, and it takes a long time. So regardless of this just being a nice, pretty chart to put in my presentation, there is a reason why it's important, because you need to understand you're not dealing with a private litigant where you just have to deal with the person who's suing you and their attorney. You're dealing with a whole host of other people. So once you understand who you're dealing with, you have to understand the laws that you're dealing with. So we call this slide "Ain't Nothing But an FTC Thing," because they tell you, sorry, I don't know what that is. I'm not even going to try to get rid of that. They tell you on their website what it is that they are going after. So I'm just going to read to you what their mandate is. The mandate is, as the nation's consumer protection agency, the Federal Trade Commission has a broad mandate to protect consumers from fraud and deception in the marketplace. To fulfill this goal, the FTC takes law enforcement actions, provides consumer and business education, issues reports and policy guidance, leads workshops, and participates in other forums. So that's a whole lot of broadness. It could be basically anything in those categories. And really, they do interpret their authority very, very broadly. They'll tell you right out, this is what we do, and what the practices that people at this forum will engage in are most likely going to fall within their authority. Do I have to click off? Click it. Sorry, guys. Oh, got it. Thank you. So we have to know the law. So I give you a sampling of the kind of laws that are going to fall within the FTC's jurisdiction. The FTC actually has enforcement and administrative responsibilities under 70 various statutes. The most important ones that you're going to find in this space are the ones I have listed over here. So I'm going to go through them real quick just to give you a flavor, sampling of the types of statutes that online marketers are going to run into. So first you have the FCRA, which is the Fair Credit Reporting Act. And this act protects information collected by consumer reporting agencies, such as credit bureaus, medical information companies, and tenant screening services. Then we have the Fair Debt Collection Practices Act. This is an act that covers the activities of third-party debt collectors, and it prohibits them from employing deceptive and abusive conduct in collection of consumer debts incurred for personal, family, or household purposes. So can't be calling people at odd hours, can't make repeated phone calls to your house, can't make threats of legal action against you. These are the actions they prescribe under the statute. Then we have the Federal Trade Commission Act, which I'm going to save for a later slide because that's the act that we're going to focus on. We have an unknown act called the Graham-Leach-Bliley Act. It's just a picture of three men, old men, who came up with this act. And basically, what that act requires is that the FTC, along with other agencies, issue regulations ensuring the financial institutions protect the privacy of consumer personal financial information. Then we have the Lanham Trademark Act, which most of you probably know in terms of trademark infringement. The FTC actually has authority under this act because they can go to the U.S. Patent and Trademark Office and say you need to revoke someone's trademark for some activity that they did. And we're going to talk about this a little later, but that act is actually used by competitors within the space to sue other competitors for deceptive business practices that could affect their business. Then we have the famous CAN-SPAM Act, which actually stands for Controlling the Assault of Non-Solicited Pornography and Marketing Act of 2003. So it's really establishes requirements for those who send out unsolicited commercial emails. But the origination of this act came from people sending you those porn emails that you see in your spam boxes every single day. The other big act that we have is the Telemarketing and Consumer Fraud Abuse Act. That is the act that talks about do not call requirements, don't make robocalls to people. Interestingly enough, the FTC actually had a contest where they had people come in and try to figure out ways to effectively stop robocallers. And they call this contest Zapping Rachel. So I try not to take it personally, but you know, it happened to be, it says, Dear Rachel, stop calling me. That's what their contest was. So I'll make sure not to call any of you all. Don't report me to the FTC. The last one is the Truth in Lending Act, and it vests the commission with the responsibility of assuring compliance with non-depository entities. So for instance, creditors need to have specific written disclosures when they talk about financial charges and related charges of credit transactions. So these are like the more famous acts. There's a whole, like I said, there's 70 of them. You can go to the FTC website, they tell you what they all are, but most of the cases that we're gonna discuss fall under these categories. Okay, so now that you know the law, you have to respect the law. What is the best way to stay out of the crosshairs of the FTC, right? That's what everyone always asks me. How do I avoid getting them coming knocking on my door? Well, know what they tell you not to do, and this is what we're gonna talk about right now. So I call this slide, and for those of you who came late, I'm trying to be cute here and have all my slides have some sort of rap or hip hop lyric on them. So if you can identify the artist or the song afterwards, I'm happy to have a courtesy legal session with you guys up to half an hour to an hour if you can identify them. So this one's called Too Legit to Quit or Slim Shady. I thought that was fitting for deceptive advertisements. So when it comes to the FTC Act, and we just talked about that, that's the act that prescribes unfair and deceptive marketing and advertising in interstate commerce. There are basic principles that you need to follow. The hard thing when it comes with to the FTC is knowing what's law versus what's rules. So the FTC has guidelines, it issues guidelines, but those are not strict laws. It doesn't say what you need to do in every single situation. For instance, if you're running a diet page, is it going to tell you where you need every single disclosure, what kind of limitations and qualifications you need? No, it's going to have examples, and you need to glean from those examples what you need to do in your situation. So when people say, you know, I kind of understand what they're talking about, it's not just fluff when lawyers say you should really hire an attorney who can help you navigate through those rules, because we know from our experience in handling these cases, what are the types of hot button issues that are going to get under the FTC skin? Is it calling something free when it's not free? Is it, you know, not having disclosures or disclaimers in the right spots? We know what is how to mitigate your risk. And that's really the most you can do, is mitigate your risk. There's no real way to avoid FTC scrutiny unless you're 100% compliant. And I can tell you from experience, I have never run into a single client, despite all my wisdom and hard work for them, that's 100% compliant. So what we do is we navigate risk. What risks are you willing to take, and what risks should you avoid? So there are certain principles that you need to abide by when it comes to the FTC Act. I'm going to go through them one by one. The first one is advertising must be truthful and not unfair and deceptive. Seems pretty easy to understand, right? but it's really not. So what does it mean to be unfair and deceptive? So I put these, every affiliate summit, the Ifrah Law firm hosts a power booth station, and we have what we think are very funny posters at the bottom, and we try to mimic and parody what's going on in the industry. So these are our previous past posters that we've had, and if you walk out of here after the session, you'll see our power booth station. You can see our new poster, but you're never going to see a guy who's that fat go from to that bulked up just by simply taking your diet product without exercise, without dieting in and of itself. That's never going to happen. But unfortunately, we see claims like that. So what you need to understand is you have to look at what are you expressly claiming in your ad and what are you implying in your ad. So even if I just had a picture of that wrinkly face and that smooth face, and I said before and after of taking our product, but said nothing else, what you're trying to imply is if you just take my pill, if you just take my skin cream, if you just take my lotion, you're going to go from that to that in a matter of weeks. So that's an implied claim. So you need to look at the net overall impression of what your ad is stating. So not just what you say, how you say it, and what you don't say in your ad is going to be important. Think of it of a mosaic. You're not just looking at the mosaic as a whole, you're looking at each tile separately. The other big problem we've seen in the advertising space is people who don't disclose their material relationship to the ad. So we had all these fake news sites that were getting shut down in the past. They're not real news sites. These were landing pages created by affiliates who were promoting other people's products. They didn't disclose that fact in there. They made consumers think that these were independent reviews by Channel 5 News or CBS News, and they really weren't. And, in the last, I want to say, how long has it been? 5-6 years, there's been a major crackdown on those kinds of advertising practices. The second principle to keep in mind is claim substantiation must occur before an ad is disseminated. What does this mean? Do not make a claim that you do not have proof to back it up, okay? If you're saying you can lose 60 pounds in 60 days, you better have proof to back that up. And you better have proof before the FTC comes knocking or before the competitor calls you out on that claim, because you can't go ex post facto and try to substantiate it by running all these clinical studies with consumers who took it. That's not going to work. You don't make a claim that you don't have proof to back up. That's the biggest thing that I always see. So that's probably going to be one of the high risk areas that you need to navigate. For instance, you see our poster outside, we talk about Dr. Oz. So Dr. Oz, everyone's kind of used him in their diet products because Dr. Oz is what I think a charlatan who goes out and tells people, drink green coffee bean, drink, raspberry keto, eat this and you'll be fine. So all these marketers have latched onto him and said, hey, let's use him in our ads and let's get him to vouch for our products. Well, Dr. Oz never actually seen your finished product. He's just talking about a main ingredient in there. So if you're going, first of all, don't use him in your ads now, even if you were using him before. And second, if you're going to refer to him in any part, you need to make clear that you're not talking about Dr. Oz reviewing your, let's call it pure raspberry ketone product. He just talks about raspberry ketone, the main active ingredient. He's not talking about how that interacts with wood, bark, or whatever else you're throwing into your supplements. And wood and bark does show up in people's supplements. Sorry. You need to make sure that you are not making claims you can't substantiate. For instance, sometimes people will say clinical tests prove or laboratory studies show. Rule of point, and I talked about this in my last affiliate speech. If you're doing a dietary supplement product, for instance, you don't need to be talking about clinical studies because, first of all, you don't need clinical studies to market your product because the FDA does not require any existing, for the most part, existing dietary supplemental products to be approved before being marketed. There's no reason to throw in clinical studies because once upon a time you Googled raspberry ketone and you found a clinical study online that supported it. Don't put things in there that are going to mess up your claims and require you to answer to other people. If you don't have a clinical study about your finished product, don't mention clinical studies in your ads. The third thing, which I tell clients, is disclose and disclose often. Unfortunately, sometimes clients are against disclosures and disclaimers because that's going to kill their conversions. If you're telling people that this is not a real person reviewing my product, they're not going to want to look at your product. Well, then again, I say don't use a product that hasn't been reviewed by a real person. So people are very against disclaimers, but disclaimers are probably one of the most important things that you need to have in an ad. And they can't be this like teeny tiny font that you have in the bottom. They have to be very clear, very conspicuous, and as close to the claim as possible. In different mediums, there are different kind of disclosures you need. So last year, the FTC actually updated its guidelines, advertising guidelines, to include blogs and social media. So if you are tweeting something about a product and you're getting paid to tweet about that product, you need to disclose in those limited character counts that this is a sponsored ad. So how do you do that? You'll say hashtag ad, hashtag sponsored. But that needs to be in there. So for instance, Cole Haan, there was a recent case involving Cole Haan. Cole Haan had a contest on Twitter. If you're walking in Cole Haan's shoes, take a picture, post a picture on Twitter, and then we'll draw a raffle and one person will win or something of the sort. And the FTC sent them a letter and said, this is paid endorsements. You can't do that. Even though not everyone got paid to do that, it was part of a contest. You need to have people disclose that they are doing this as part of a paid contest. While Cole Haan didn't get in trouble and just got a warning letter of the sort, this is an issue that's going to become more prevalent. At the time, the social media guidelines were very, very new. So there's a lot of interpretation that's still going on with those guidelines. So there wasn't really an enforcement effort against Cole Haan for that, but it's a warning to the industry as a whole. Also, when you talk about mobile, with the advent of mobile, there's so many new claims. So how do you get a disclosure into like a limited spot? Well, the FTC's position is if you can't fit it in, then don't make the claim. If you can't fit in the disclosure, then don't fit in the claim. And so you have to keep some certain principles in mind when you're making disclosures. The placement and proximity of the disclosure, the prominence of the disclosure, whether it's going to interfere with the text and the graphics of the page, how often you repeat it, the clarity of it, if you're using, let's say, audio clarity on mobile, if it's an understandable language. If you're marketing to a Spanish-speaking audience, don't put your disclosures in English, and vice versa. And how the formatting and the language of the disclosure looks. So when you're talking about disclosures, it's not just about disclosing, but it's about disclosing it in the right mediums, the right way. And then finally, we talk about limitations and qualifications. Often you can use a disclaimer to limit your claim. So for instance, if you're saying your product is free, but it's not really free because the person needs to pay for shipping and handling, perhaps you should say free plus shipping and handling, or free plus other terms apply. Now, it's never good to use the term free unless the product is truly free. But if you're going to say something is free to get people interested in your product, you need to disclose whether there's going to be a rebill, a trial offer, a shipping and handling costs, right the very first time you make that claim. Also for qualifications, let's say you are promoting, again, I'll go back to the famous dietary supplement product. You're using a picture of a doctor in your ad. Let's say it's a real doctor, but it's a dermatologist talking about a diet product. So you need to disclose that this is not like a nutritionist, a dietitian, an internist. This is a dermatologist. They're only qualified to opine on what they know. So you have to let your audience know that while I'm using a doctor in the picture, it's not a doctor who necessarily focuses on health and diet. So, but point is, don't use those kind of doctors. Use someone who is actually qualified to talk about what you're asking them to talk about. So again, it's not just what you say, but what you don't say that matters. Okay, so now you know the law, you're respecting the law. What's the process? What's going to make you a target? This slide's called Can't Touch This, but I think this is what the FTC actually can touch. So really broadly, they can touch anyone who's engaged in interstate commerce. That's really a very, very broad thing. Anyone who is marketing over state lines, who's in the online marketing space, is automatically going to fall into that category. So I actually advise some clients, this is not going to affect you from being scrutinized by the FTC, but if you are in certain jurisdictions where enforcement is hot and heavy, for instance, Utah, Florida, where their AG's offices are a little bit more aggressive, you may want to think of blocking those states and not doing sales in those states. And clients have found that that's actually been more helpful. Now, there's always going to be that odd person who lives in Utah and bought your product somewhere else and then goes to their Utah AG, but that's, for the most part, that's going to be a safety measure that you may want to implement, especially if you're in a high-risk category. So that's the rule, and the exceptions are if you're regulated by a federal banking agency like the FDIC, you don't fall within that jurisdiction. You're regulated by the FCC, or you're regulated by a state insurance regulator. So those are the few folks who are going to get the pleasure of working with a different federal agency. There are times when federal agencies collaborate with each other, but for the most part, everyone kind of falls within their own little region. So what makes a good FTC case? Well, I think the picture speaks for itself. It's headlines and money, right? What is the headline of the moment? Where is the money? The bigger the money, the more exciting of a case it's going to be, the more of a priority it's going to be for the FTC. So what's the issue? Is the issue of the moment privacy, data breaches, protection of children? Is Dr. Oz testifying in front of Congress, talking about green coffee bean? That's the issue of the moment. What are the practices that are going to cost consumers a lot of money? Is it these rebuilds, free trial offers that are really becoming an issue? That's always a hot topic. What is an industry that has no congressional support or very little congressional support? Because again, remember our first slide, we talked about how the FTC receives its funding from Congress. So they're going to prioritize certain industries and certain matters more than others. So if you have lobbyists working for you and you have strong congressional support, you may not be high up in that ranking of people they want to go after. Who are the companies with name recognition who are going to create a precedent for others? Like Skechers, they had those shoes that said if you walk in these shoes, you'll tone up your legs, those Skechers toners. The Cole Haan example I gave you. L'Oreal just had a settlement for their Youth Code Skin Rejuvenating Cream. These are the big companies with the deep pockets, and they're going to make headlines. So those are the companies that the FTC is going to go after. And they're going to go after the deep pockets. Why? Because they want to set a precedent for later. They want to say, look at this judgment we just got from L'Oreal. We got $35 million from them, let's say. Well, I mean, all these other companies are not going to be able to afford that, but they use that as a yardstick moving forward. So now that you know the process, you have to know what are they going to go after? What are their top enforcement priorities? And they're pretty much the same for the last, decade, but protecting consumer privacy, dealing with, COPA, the Children's Online Privacy Protection Act, HIPAA-related issues, how you collect personal health information, protecting economically vulnerable consumers, mortgage relief ads, debt settlements, anything that has to do with people, especially in a recession, saving money, work from home, if anyone actually still does those things these days. I think I met a gentleman who said he still runs those kind of offers. I was a little surprised by that. Those are the things they're going to go after. Monitoring environmental claims, that's a new one. The FTC has what they call green guides. So, for instance, they went after a window manufacturer who made claims about energy savings that weren't substantiated. What's trending in technology? What are the hot topics in technology? Data collection, always going to be an issue. Mobile, always going to be a hot issue. Again, challenging deceptive advertising and marketing, that's just a general priority that they have. But for instance, Palm Wonderful, the Skechers example, the John Beck's Get Rich Quick scheme that people had. Anything that is flashy and stands out as a claim that seems deceptive and it's going to create consumer frenzy to get that product, that's what they're going to prioritize. And of course, children, children now have phones and tablets and all that other stuff. So how do we protect them, and how do we protect their information, and how do we get proper consent for them to be on our sites? So I just have a chart here that shows you, and this is straight from the FTC, what the top enforcement trends have been like for the last 4 years. They're based on the number of complaints received. The FTC kind of makes it easy for you to submit a complaint. I mean, it may get lost in the bureaucracy, but starting in 2010, we had like about 1.3 or 4 million complaints, and then in 2013, over 2 million. And you can see the top two lines, identity theft and debt collection have been the top two consistent enforcement trends in the last 4 years. So we have, shop and home, we have credit card, auto-related sweepstakes and lotteries, mobile, telephone, that's huge. But these have been consistent throughout, and they, kind of switch positions. The top two have remained consistent. And they issue these every year, in the March of the following year, they'll issue what were the top complaints for the prior year. So now you have to know the process. If you fall into any of these categories and you are marketing to any of these types of vulnerable populations, the elderly, the impoverished, the children, the overweight, you are going to have to know what to do if the FTC comes knocking. So first you have to understand, how does an FTC case develop? We call this next section, don't hate the player, hate the game. So we're going to learn what the game is here. So what are the triggers for an investigation? So they'll start out, the FTC wants to do as little work as possible to figure out what the hottest topic is as possible. And often they don't need to do that work themselves. They'll get that information elsewhere. So if you have a lot of complaints that are being sent to the Better Business Bureau or the state AG's office, that's going to trigger something in their minds that, okay, we need to go after this company. And this is what I tell clients. You need to have good customer service. If someone is calling to complain about a $16 charge, give them back their money, okay? Because otherwise you have to pay me my hourly rate to respond to that state AG complaint, and then you have to pay a bigger fine if you don't resolve that. Just give them back the $16. It's not worth it. Don't try to negotiate for I'll give you back 33%. They're going to write a letter, and you should not be getting stacks and stacks of letters sent to, especially the same state AG's office. Because eventually, that state AG is going to say, okay, there's too many, and we're going to collaborate with the FTC to go after this particular industry. Then we have what's called surf days. At the FTC and other agencies, the FDA has this as well. They actually go on the web. They have people dedicated to going on the web, seeing what is popular out there. They actually have people dedicated to coming to conferences and talking to people. You may not know you're talking to someone who's checking you out or surfing you, but they do. They show up to conferences, and they're very well aware of what the market looks like. So they go and do their own investigation. You also have private litigants, people suing you, making public records of the fact that you are doing something that's unsolicited or that's deceptive. For instance, classic example, people suing for violations of the Telephone Consumer Protection Act. You call me, it was an unsolicited call, I didn't give you my consent, I'm going to sue you as part of a class action. And there's a whole cottage industry of plaintiffs' lawyers just waiting to jump on you to get that money. And often there will be a corresponding case that will come out from the FTC related to that. So for instance, the case I was telling you about before that I handled involved unsolicited text messaging. And there was corresponding private litigants who were suing these same people who are being sued by the FTC at the same time. Lastly, you have your competitors. So there's two scenarios. Either one, as I was talking about before, your competitors are suing you for claims that you made that detract from their product, and they can do that under the Lanham Act. For instance, if you say your product is number one, but you don't have substantiation, and their product is actually number one, they can sue you for that, for what's called a trademark violation. The other scenario is you can be doing everything right. You can get, you have your terms, you have your contracts, you have your pages, you have your disclosures, but you're affiliated with people who are doing something shady, and they get scrutinized by the FTC. So what happens? They get sued or they get investigated. They need to turn over the names of all the people they work with. Your name is on that list. So you get a call from the FTC staff attorney saying, hey, Mr. Joe, I got your name from this company. I need you to send me all the records you have from everything you did with that company, regardless if it has anything to do with the actual substance of the case against that company. I've seen that happen more often than not. I've seen people falling into the trap of giving them everything and just trying to be super cooperative, which is not always the best tactic to take. And then you're just giving free information to the FTC about other areas that they may not be interested in. So if they're suing a company for unwanted text messaging and they go after the partners who are doing email marketing, there's no reason the email marketing stuff should have anything to do with the text messaging. But I've seen too many people turn over information readily to the FTC, and that's just giving them away. Here's a new case you can bring against email marketers, even though you weren't thinking about email marketing at the time. So that happens as well. So how do they find their targets? Well, sometimes they'll go after the low-hanging fruit. That lowly affiliate who's sending out all these pages, they don't want him. He doesn't have money, but they go after him first. They send him a letter. They send him a subpoena. They send him a CID, which we'll talk about. The reason they want him is to get to all the other people on top of the food chain. So they'll go after him for a fine, and then they'll get all this information they need about the advertiser, their network, and that's who they want. Other times they'll look at specific practices. Is rebilling an issue? Are free trials an issue? They'll go after that. Again, other times they'll go under industry-wide sweeps. People are robocalling. People are, acai berry, diet scams. They'll go after the entire industry, and usually the deeper pockets in the industry are going to get hit with the largest fines. So what happens if you do get in the crosshairs of the FTC? Usually, sometimes, but not always, they'll actually come to you first, and you'll have some sort of warning that they are coming. So they may initiate an investigation and collect information through one of two ways. They'll do it either informally through an access letter. They send you a letter telling you that they're interested in what you're doing. There's voluntary cooperation with that, and can you voluntarily cooperate and give me information? That's the informal way. The more formal ways, they'll send you either a subpoena or what's known as a civil investigation demand. And often, if you don't respond to the access letter, they may go that route and send you the CID right away. So those are the informal ways of, hey, we're here. Here's a warning that we're looking at you. Often, though, there's no warning at all. If they think that you're in an industry that's really high risk, for instance, mortgage scams, debt relief, financial services, they're going to seek immediate relief by going to the court, asking for a permanent injunction against you, seizing your assets, getting a monitor put in place, getting what's known as a temporary restraining order. All these things are not fun because you don't know it's happening, and all of a sudden you're trying to access your bank accounts, and all your money is frozen. Usually one of your business partners will let you know, hey, I didn't get paid this month, this wire got rejected, what's going on? And that's how you find out. That's not in every case, but in some cases, they'll just, file a complaint and they'll ask for a TRO, but they won't actually seize your assets. So the best result that happens from this informal proceedings is that, they go in and they see that you're not doing anything and they send you what's called a closing letter. We're done and we're not really interested in you. Best case scenario. Worst case scenario is that you get the CID and you actually have to respond to it. So, as I always try to do, give you some tips of what you need to do when you get a civil investigation demand. So first, these seem obvious, but they're really not to most people. Read it thoroughly. What is it saying? What are the deadlines? How are the terms defined? For instance, they're going to ask you send me all documents relating to this and this topic. Or they may phrase their question as, send me all documents sufficient to identify this or this topic. Those are actually two different things. So you need to read it carefully and see what they're asking. Make sure that you know that the information you give them is confidential, treated that way. And you have to certify your responses. Make sure you fully understand what you're certifying. Second, preserve immediately. When you get a CID or a subpoena, you have to institute what's known as a litigation hold. You tell all your employees, no deleting emails, nothing can be changed, no shredding documents, everything has to be preserved. Don't do routine maintenance, technical maintenance, if you don't have to do it, because this information is part of now an investigation. Third, communicate thoughtfully. Reach out to a staff attorney. Tell them, hey, what is it you're looking for? This is such a simple question most people forget to ask. Talk to them and see what they want and create a relationship with them. 4, negotiate carefully. Sometimes they may not be interested in all those topics. They may just want one particular thing. It's always important to ask them, what is the scope of the request? Do I have any extra time to respond? Can I get that in writing? Make sure you do that carefully. Produce cautiously. Make sure that you are understanding what you're turning over. Even if it's bad for you, you're probably going to be obligated to produce it. So that's not an excuse not to produce it. But if it is bad and sheds you and puts you in a bad light, make sure you're communicating with your counsel or your corporation why you think it's bad and what the ramifications will be of exposing that information. Which leads me to respond substantively. Sometimes things are going to look bad, but they may not actually be bad. So often what we do for clients is we'll put together what we call a white paper, explaining the law, explaining the facts, saying why we think, even though this looks bad to you, it's not actually that bad. Then preserve confidentiality. This is very important. Make sure you mark all your papers confidential. Often you can ask the FTC to return the documents to you if the investigation closes, but make sure this is a private proceeding, that nothing gets released to the public domain. Choose wisely. This seems obvious, but make sure you hire counsel to handle this for you, okay? Experienced counsel, because you don't want to be turning over something that you don't understand, and your counsel may have relationships with these staff attorneys that could help you in the long run. And you don't need to always go to the staff attorney. If they're being slow or they're not being receptive, you can go above their heads and move up the chain of command. And they welcome that. They offer meetings and they let you speak to the bureau heads. But knowing counsel who knows these attorneys may be helpful to you. Move quickly. Don't let the holdup be something on your end. You haven't produced the documents when you need to produce them. It's going to be a long wait, but you don't ever want it to be your fault that you didn't move this process along more speedily than it could have been. Even if you do, you need to wait patiently. Sometimes these investigations takes months. Sometimes it takes a year, and you have to be patient. And the biggest problem I've seen when it comes to FTC, and why the FTC always wins, is people run out of patience. They don't know how to sit still because their company's being affected by it. Thankfully, CIDs are private, so most people are not going to know that you're being investigated. But people want to get it wrapped up. They want to move on to different things. They don't want to be focused on it. And so they'll usually negotiate something that's probably not beneficial to them, just to speed up the process. So sometimes if you have a CID, you can settle by a consent order. Consent orders can happen at any time pre-litigation. So if they determine that there are enough facts against you that look bad, what they may do is send you a letter with a draft complaint that they're going to file against you, and they'll send it along with a consent order. And they'll say, you can either settle now or we're going to file this complaint. But once they file that complaint, these consent orders are not happening. So your time to negotiate is pre-litigation. They need actual authority from the Bureau to enter into consent orders. The staff attorney does not have that authority on its own. But like other orders, settlement orders, they have the boilerplate provisions. You have to report periodically of what you're doing. You need to, you have civil penalties and fines. You're permanently banned from doing certain activities. You have to disgorge all your what they call ill-gotten gains from this deceptive practice. So what happens when you file a consent order, or enter into a consent order, is that your private investigation now becomes a public headline, because the FTC does do press releases, and people will now know, hey, this company was being investigated. But what happens if you don't get into that consent order? You get into litigation. So there's two types of litigation you can enter into. There's administrative actions, which more likely than not come up in, like antitrust, anti-competitive behavior. Not going to necessarily affect most of the people in this space that are here today. But the other option is litigation. So in the administrative action, actually, the staff attorneys they prosecute the claim. There is an administrative law judge. There is approval by the commission. In a sense, the FTC becomes your judge, jury, and executioner, because they are involved in approving the settlements. It gets appealed to, even if it gets appealed to a federal court at some point, they usually defer to the commissioner's judgment on this. There's a lot of bias there. In fact, LabMD, which is a very, it's a testing lab, actually tried to get the Commissioner Julia Brill to be recused from one of their cases for this very reason. Why are you being judge, jury, and executioner on my case? It's unfair. You can't have every say. You can't tell me I did something wrong, prosecute me for it, and then punish me all through one person. Most people, though, are going to have litigation in a federal court. Usually a federal court is where they conduct a business, where they're located, where they live. But even in FTC cases, in court, where the court is, has nothing to do with the government, they're the judiciary branch, there is a bias toward the government. And you see this in, for example, you'll go and have a preliminary injunction hearing, or you'll have a TRO hearing, and you'll say, Judge, this TRO is so broad, it violates our First Amendment rights, and I've done this, and this covers behavior that doesn't have anything to do with the complaint. And what's the FTC's response? Judge, we're the FTC. We get these entered all the time. I mean, literally, that is the response. And the judge may say, you're right, it is broad, but they'll pretty much enter whatever the FTC wants. Now, there are exceptions to the rules, but you see that more often than not, that the FTC says, hey, Judge, we are the government. We get to do what we want to do. Litigation is also a much longer process than an administrative action, which is supposed to be more expeditious. But it is, there are advantages to both, and they have similarities, like the exchange of discovery and conferences and depositions. And they do seek the same type of relief, injunctive relief, civil penalties, restitution. Litigation will also have reporting requirements and lifetime bans if need be. But, these are all public proceedings. In fact, administrative action is a public hearing, so anyone can attend those. And anyone can go to court and sit in on your trial or your TRO hearing, unless it's for some reason under seal, which is rare. So just want to talk about, I have three, and we're running low on time, which is why I'm speeding it up, but I have three different verticals I wanted to focus on settlements in the last, 4 or 5 years. So we have health and beauty, financial services, debt management, and telemarketing. And I call these slides Ain't Nothing But a Gold Digger, because they're looking for the money. So some of these cases have been resolved as part of an administrative hearing. Some have been resolved as part of, a consent order. Some have been resolved as part of settlement. What you're not seeing a lot of is trials, right? You're not seeing people really go up against the FTC. You're seeing the FTC, what I call win. Why are they winning? Well, the reason is, there's a lot of reasons why people don't win. Trials don't really happen because a lot of these FTC staff attorneys, they're not litigators. They don't want to go to court. They don't want to have a full-blown trial. They will if they have to, but they rather settle your case, get it off their desk, and move on to the next investigation. I often think people give the government too much credit for how, not that they're not smart, but how smart they are. People will be afraid to go to a deposition, and then they'll get there and they'll think, hey, this wasn't so bad. He didn't ask me anything hard-hitting. And they're actually surprised by, how, I want to say low level it is, but low level it is. They're not, some of them are not litigators. They don't go to trial. But the other reason why cases settle is because, it's hitting your bottom line. Your company's being affected by it. You can't run your company the same way without getting this off the plate. Your business partners want to see that this has been resolved. So you risk a huge judgment against you. You settle earlier than maybe you should have because you just want to get this over and done with. Why else would you settle? The case has taken so long, you ran out of money. You don't have money to pay for your lawyers, It's a true story. Lawyers don't work for free, unless you're pro bono lawyers. They need to get paid, and you want to settle your case. Often, though, that can work to your advantage because if the case has taken so long, you may be able to settle on what's called an inability to pay basis, where you don't have money, so what would have been, let's say, a $6 million judgment becomes a $5,000 judgment that results from you selling one of your cars to be able to pay them. So sometimes time works to your advantage. Why else would someone settle? Because they don't understand the process. This is what we've been talking about. They don't know what to do. They acted too late in the investigational phase. They didn't hire an attorney to help them. They gave over everything they needed to give over, and they didn't negotiate. They didn't work the chain of command. They didn't go above the staff attorney when they had the chance and talk to bureau heads or commissioners or anyone else they may have had and really see if they had a different view of the case. They were too willing and eager to give the government everything they wanted. You do have a right, especially in litigation, to challenge requests for information and say that they are objectionable, they are overbroad, they are irrelevant, they are privileged. And often people don't use their time wisely in litigation. When you're trying to settle a case, if you go in with the mode of, I want to settle this case, you need to understand that that's all great and good, but the litigation track continues at the same time the settlement track continues. There are two trains going at the same rate, often litigation going faster than settlement. And this train's not going to stop for this train. So you better use your time wisely. Even if you want to settle, litigate the case, ask for discovery, challenge your expert witnesses, challenge your consumer complaints. Don't just sit back and be defensive and be reactive, but be active and be on the offense and send them discovery and really try to do depositions if it makes sense in the case to do so. Because what often happens, more often than not, that even if a case gets so far along the road and it gets to the point where discovery is over and they're filing substantive motions to the court, what happens is they'll file what's called a summary judgment motion. You say, hey, judge, there are no facts in dispute in this case. All that's in dispute in this case is the law, and the law is clear. So there's no dispute to that as well. And that happens because you have already given them everything they need against you. All the facts are bad, so there is no dispute of facts. So the judge just looks at the law, and unfortunately, the law is very, very, very favorable to the FTC. If you're trying to contest their burden of proof or that they haven't established this or that, just look at the case law. It's so lenient toward them. There's not a lot of cases where the FTC loses on those kind of challenges. You don't want to get that far down the chain without having done work on your own. So these slides are available so you can take a look. So what happens if the FTC comes knocking? So I call this slide, Mama Said Knock You Out. So how are we going to do this? First thing first, don't panic. Make sure that you have a predetermined plan of action. First thing is to educate your employees. Make sure your employees know that there are practices and procedures in place if they come in contact with a government official. And it may not just be the FTC. Sometimes the DOJ shows up at your door. Know how to react. Designate a corporate representative. Have one person speaking on behalf of your company. It could be an in-house attorney. It could be outside counsel. It could be a corporate executive. But one person should speak on behalf of the company. And that should be the contact for the government. Identify the purpose of the visit. Are they coming up for you? Are they coming for one of your partners? What are they trying to gain out of this visit? Sometimes people become very defensive right away, and it has nothing to do with you. They're actually there to talk about an affiliate, a network, advertiser that you're dealing with. Contact counsel. You want to make sure that you don't need to talk to the government when they come knocking at your door, especially if it turns into a criminal inquiry. You have FBI agents at your door. You can tell them, I want to talk to counsel. It's voluntary to talk to them. And then also involve counsel post-visit. Make sure that you're doing a proper follow-up, that you have procedures in place, and that you know what you're doing. But most importantly, don't panic, because these things happen all the time. And if you're working with people who are experienced, they'll know what to do in these situations. So that leads me to my last slide. If you do all these things, you may have 99 problems, but the FTC won't be one of them. So I hope you guys enjoyed. Sorry I had to speed it up at the end, but I think I have a minute for questions. Does anyone have any questions? Yes. Yeah. Well, they're saying the consideration was that the person who had the pictures of them walking in the Cole Haan shoes, someone would win. So it's not really a paid endorsement because not everyone who entered into that contest was going to win. But there was a promise of consideration at some point, so the FTC looked at that as an endorsement of Cole Haan. And because it's a paid endorsement, they wanted that to be disclosed in the tweet. Anyone else?
You're talking about a lot of the merchants, but where does the liability end with the merchants versus an affiliate?
It can go up the chain or down the chain. So if you're the merchant and you're responsible for, or let's call you the advertiser, you own the product, right? You own the offer, and you're giving them the creatives and you're telling them what to do, there's going to be a lot of liability on your end. You also need to be monitoring what your other partners are doing. So if you're hiring a network to run your traffic or you have an affiliate running your traffic, you can't really turn a blind eye to what they're doing. If you go on the web and you see that your products are being promoted in a way that's deceptive, you can't say, well, it's not me doing it, it's them, and I have an indemnification provision in my contract that says I'm indemnified. Well, good for you, but the FTC doesn't know that you have a private contract, and they don't care about that. It's still your responsibility as the owner of that offer to make sure that people working for you are doing this in a way that doesn't get you into trouble.
And if I were an affiliate, to what extent do I need to be doing my own due diligence that the merchant is saying the actual truth, right? Like, so I'm, you know,
Right.
like if I'm an affiliate saying, well, that's not my fault. That's what they told me to say. Like,
Well,
where does
some
that-
things are obvious. Like if they're telling you that you lost 60 pounds in 60 days, I mean, that's something you have to question. Again, don't turn the blind eye. But unfortunately, affiliates are not necessarily always in the best negotiating position. They can't negotiate contracts with the advertisers. They can't get the representations and warranties they need because the advertiser is saying, if you want to promote my product, you have to sign my contract, and this is what my contract says. So, you know, contractually, you can try to protect yourself from that, but you also have to use common sense. And you have to think, what is the reasonable consumer going to think about what I'm trying to say? And if you think someone's doing something shady, then you probably should not be working with that person, and you're putting yourself at risk and them at risk as well. Anyone else? Well, I really appreciate that you all came today. I hope you enjoyed the slides. I tried to keep them a little funny with the titles. So like I said before, please fill out the forms at the end evaluating the session. And if you were able to tell me who those lyrics were, who some of the artists were, I'm happy to schedule a consulting session with you guys. And I'll be outside at my booth right here at the power station. So come by. I'm there all day and happy to talk to you some more. Thank you.